What's up, guys, and welcome back to my reading journey. I hope we're all doing absolutely great, and today, as usual, we're going to continue with the book by Cicero on the ideal orator. It's going to be the 49th part of the first book, so let's get started. Can you really, Crassus replied, to pass over the other countless and immensely important subjects, and to come to your own civil law? Can you then really regard as orators the men who had attained Publius Scaevola for many hours, while being eager to get to the Campus Martius? He was amused and exasperated at the same time. I am referring to the occasion when Hypsias, at the top of his lungs, with a barrage of words, was demanding from the praetor, Marcus Crassus, permission for his own client to forfeit his case, while Gnaeus Octavius, a former consul at that, gave a speech every bit as long for the other side, though he was actually pleading against his opponent forfeiting his case and against his own client's chance, afforded by his opponent's stupidity, to escape from the disgraceful trial about his guardianship and from all the distress involved. No, indeed, said Scaevola. Such men, for I remember Mucius telling me this story, I could hardly have considered worthy even to enter the forum, much less to be called orators. All the same, said Crassus, these patroni were not wanting in eloquence, or in rhetorical theory, or in fullness of diction, but in knowledge of the civil law. Hypsias was planning in the actual proceedings stipulated by law to claim more than the law of the 12 tables permitted, and had he carried his point, he would have automatically forfeit his case. Octavius, on the other hand, considered it unjust that more should be demanded from his client than was provided for in the legally prescribed phrase, failing to understand that, were the trial to be conducted on that basis, his opponent would lose the suit. And how about what happened a few days ago? As I am sure you have heard, while I was sitting among the advisers who had joined my friend Quintus Pompeius, the city praetor of his platform. One of our clever speakers applied for his client, a defendant in that case, to be granted the insertion of the old and familiar clause, only with respect to money already due. He failed to understand that this clause had been devised for the protection of the claimant. Thus, in the event that this debtor, who was denied his obligation, should satisfy the judge in the actual trial that payment of the loan had been demanded before it had come due, the claimant would not be prevented from bringing a new action by insertion of the clause that this matter has already come into court. Alright, guys, we've done with this part, and we're gonna continue tomorrow the next one, as usual. So, thank you for joining me in this video. I'm gonna see you tomorrow. Bye.